We got a call from Carolyn O'Neal. She described just a nightmarish encounter with the Canyon City Police and the Fremont County Sheriff's Department. She was living in a facility where she was getting rehabilitation. She's not a young woman. She's in her late 50s, and she had had drug and alcohol problems. She had been grossly abused throughout her entire life. And she got a job, and she was maintaining sobriety, and her mother was dying of cancer, which really threw her into the depths of despair. She came back from work one day and told the manager, "Oh, I had such a great day, I should probably just drive my car off a cliff. It was that good." Well, the manager then thinks, that's a suicidal threat, so he calls the police. The police come out and start knocking on her door. The police say, "We need to talk to you, open the door. You've made a suicidal threat." They walk in on her. She is completely naked. She starts screaming at them to leave her apartment immediately. They obviously can see she's not harming herself. There are no weapons in her hands. These male cops throw her down on a bed naked, which triggers all kinds of horror in her mind. They cuff her. They throw a blanket carelessly on top of her. They drag her out of her own apartment with no warrant, with no nothing. They take her to the jail. They put a spit mask over her head. They leave her naked in a restraint chair in the Fremont County Jail. All of this is on videotape for 4 hours. She's very slightly built. She manages to wiggle her right foot free from the restraint. And what does she do? She crosses her legs to prevent the inmates across the way from seeing where they shouldn't be looking. A deputy walks by and sees her peacefully sitting in a restraint chair all by herself in her own cell with her legs crossed and says, "Oh my God, she's gotten her ankle out of the restraint chair." So they assemble a team of deputies to come in, and they forcibly uncross her legs, and they're saying, "Put your foot down, put your foot down." And she is screaming, "No, get out of here, leave me alone." So they tase her while she's naked in the restraint chair, forcing her foot down, and they re-restrain her. After 4 hours, they take her out of the restraint chair and leave her naked in her cell for another 8 hours. Ultimately, all charges against her for disturbing the police, which is what we call resisting arrest and obstruction, were dismissed. We take it into federal court. The best pretrial settlement offer we got was $20,000 2 weeks prior to the commencement of trial. $20,000, are you kidding? So we took it to trial, and the jury came back with a $3 million award. Sadly, this was the last case Wiley Daniel tried as a federal judge before his passing, and I think he was pretty outraged by the facts of this case. We ended up settling the case while it was pending in the 10th Circuit. The best take-home lesson for trial lawyers is we had almost all of this either on audio tape or videotape. This was pre-George Floyd, and that became our absolute best friend in court. If it's just your client's word against the word of the cops generally win that battle because the love of cop exists in federal juries. If you have police misconduct on audio or videotape, don't be bashful about taking it to a jury. Carolyn is the sweetest, best client in the world. She used the money to buy houses for her children. This made a huge difference in her life. It sent a gigantic message to law enforcement, at least in Colorado, that don't think your word is going to be enough to overcome the evidence of police misconduct, because now in 2021, it's a new day with video evidence coming in that tells the jury the true story. On behalf of everyone at Kilmer Lane and Newman, I just want to thank CTLA very, very sincerely for this great honor of just being mentioned in the same breath as the other cases that are involved in this evening's event. So thank you all so much. Greatly appreciated.